Chapter 8 Indemnity and Guarantee Section 124 to 147. In which one of the following consideration is not required? Contract of bailment. A contract between an insurance company and a vehicle owner to save the latter from the consequence of vehicular accident is contract of indemnity. Contract of insurance is a contract of indemnity. Section 124 of Indian Contract Act include under the contract of indemnity the losses caused by the human conduct. A contract of insurance is what kind of contract? Contract of indemnity. A contract by which one party promises to save the other from loss caused to him by the conduct of promisor himself or by the conduct of any other person is called contract of indemnity. Ramesh employs Suresh to beat Mahesh. Ramesh promises to indemnify Suresh against all of the consequences of the act. Suresh beat Mahesh and has to pay damage to the Mahesh for beating the committed upon. Ramesh is not liable to indemnify Suresh for those damages. A and B go to the shop. B says to the shopkeeper, "Let him have the good. I will ensure you are paid." This contract is indemnity. A X, a publisher of the newspaper, agreed to publish Y, request a defamatory article in respect of Z. Y agreed to indemnify X against the consequences of the publications. In a suit for Z, X has to pay the damage incurred expenses. Which one of the following is the correct statement of the liability of Y? Y is not liable as the act was criminal. Which type of loss are not covered by the contract of indemnity? Loss arises from accident are free or pearl of the sea. In a contract of guarantee under Indian Contract Act 1872, person for whom the guarantee is given is called principal debtor. A say to B that he will give sum of rupees 5,000 if B marries his daughter. This is contingent right. A guarantee which is a creditor has obtained from means of keeping silence as a material circumstances is invalid. Under which provision of Indian Contract Act bank guarantee is governed? Section 126. A contract of guarantee has been defined under (126) of Indian Contract Act. Mark the correct answer in respect of contract of guarantee. It may be in writing, it may be in oral. A sell a delicious good to B. C afterward without consideration. C afterwards without consideration agreed to pay them in default of B. Agreement is void. The liability of the surety under contract of guarantee is coextensive with the principle of debtor. A surety for B for the loan of rupees 1 lakh which B defaulted is liable for 1 lakh rupees. The liability of surety is coextensive with the principal debtor. It has been provided under Section 128. In the case of guarantee, the liability of surety is coextensive with that of the principal debtor. A became surety to C for B's conduct as a manager of B bank. Afterward, B and C contract without A permission that B shall become liable for 1/4 of the loss of overdraft. B allowed the customer to withdraw the bank loss of sum of money to make good this loss A is not liable. Extent of COT liability has been provided under Contract Act Section 128. A is consideration that B will employ C in collecting the rent of the jamindari. Promises B to responsible the amount of 5,000 for due collection and the payment by C of those rent. This is continuing guarantee. Continuing guarantee has been defined under Section 129 of Indian Contract Act. What is a term used to describe guarantee, which is intended to cover a number of transactions over the period of time? Continuing guarantee. A continuing guarantee may, at a time of revoking by the COT of notice of the creditor as to the future transaction. A continuing guarantee under this section of 130 is revocable as regard to the future transaction. A variance of the contract without COT of consent of discharge him as the subsequent transaction between the principal debtor and the creditor. True. When the COT to the bond dies before the bond is forfeited, the liability in the respect of bond shall be discharged. M lent to 1 lakh to N. P is the COT. The contract provides that liability of P shall be limited up to 50,000. The contract is valid. A guarantee can be oral or in writing. A, B, C are COT for D. Enter into the 3 several bond, each in the different penalty, namely A is the penalty for 10,000, B is the penalty for 20,000 and C is for 40,000. Condition for D duly account to E. D make a default existence of 30,000. The liability of A, B, C each is liable to pay. The liability of the COT is coextensive with that the principal debtor unless and otherwise provided by the contract. A variance made without the COT consent in the term of the contract between the principal debtor and the creditor discharge the COT. The transaction to the subsequent to the variation. In which one of the following circumstances COT stand discharged? By the release of discharge of the principal debtor by variancy of the term of the contract. C advance D his tenant of 22,000 on the guarantee of A. C has also further COT of 2,000 by the mortgage of the furniture. C cancelled the mortgage, B became insolvent and C sue A on his guarantee. A is not discharged from the liability. The Contract Act liability of COT is conditioned on default.